Hello and welcome to this special Catholic focus on end-of-life issues. I'm Deacon Pedro. We're here in Edmonton and we're looking at end-of-life issues because, and many of you might not be totally aware of this, but our legal landscape in this country, in Canada, is changing. The criminal code is being changed to include what is being called medically assisted dying. But what does that mean? What does the criminal code currently say? What are the proposed changes? How did we even get here? To answer some of those questions and some others, I'm now joined by a lawyer here in Edmonton, Kate Faught. Thank you, Kate, for helping us kind of unpack this a little bit. Well, maybe we should start with what is the current law in Canada? What does the law say about people killing other people or committing suicide?
Well, we're in somewhat of a kind of no man's land here for the next couple of months at least. In February of 2015, the Supreme Court released their decision in a court case called Carter in Canada. And in that case, two sections of our criminal code which make it illegal to assist or coerce someone into killing themselves by either providing means or knowledge of how to kill oneself. Those two provisions were found to be unconstitutional insofar as they relate to a physician assisting the suicide by our Supreme Court. When the Supreme Court issued their decision in that case in February of 2015, I think properly they realized that that was a significant shift and they needed to give government some time to respond. So they suspended the operation of their decision for 1 year. So that meant that for until February 6th, 2016, the criminal code provisions stayed in place as they always had been, with the understanding that this was coming down the pipe in 2016.
Can I just interrupt you for a second? And there might be, I think most Canadians don't really even understand how this works, but people outside of Canada might not. How is it that the courts, because it sounds like we're changing the law here, so the courts are telling the government to change the law. That's how it works.
Yep, so all laws in Canada are subject to the Charter of Rights and Freedoms, which is a part of our Constitution.
Okay.
Every law in Canada, whether it's a federal law, such as the Criminal Code, or any provincial laws passed by any provincial governments, have to comply with our Constitution and therefore with our Charter.
Right.
If any laws are passed that the courts find come offside or violate your rights under the Charter or any element of the Constitution, those laws are invalid. And so that's what happened here with our Supreme Court of Canada and the two provisions from our criminal code.
Right.
There was a court case brought that
challenged
those two sections, and the court this time did find that they were in violation of Canadians' rights under the Charter.
Interesting. So then the court gave the government, in fairness, a year or a little bit more than a year to sort of figure out what they were going to do.
Yeah, they gave the governments 1 year, and the government, actually the federal government brought an application that was heard in January of 2016,
so it was extended.
Asking for another 6 months, especially given that there had been a change in government.
Yes.
So they were asking for 6 months. The court would not give them the 6 months. They gave them all governments 4 months additional. So that time period is up in June 6th.
June 6th, 2016.
That's right.
And you're saying governments because this is not just a federal issue, but it's also provincial, or how does that work?
That's right. So the federal government will have to, or may respond in some way, because the criminal code is a piece of federal law that's under the federal government's jurisdiction. And that law is obviously affected. And if the federal government wants to change the criminal code in some way, they will be free to do that.
Right.
But provincial governments also have a hand in this. They have something to say, likely, because health is a provincial jurisdiction under the Constitution. So likely, at least in a regulatory sense, in terms of passing rules or systems or mechanisms under which this will be available to people, that may well come under provincial jurisdiction.
I want to ask you about that, but because it's a health issue. But before that, so the law is being changed. What are some of the proposed changes?
Well, that's where the vacuum comes in right now. The Supreme Court's decision doesn't put in place a new mechanism or any regulation for this. It's just said that physicians who assist people to die when they meet 3 conditions that are set out in the Supreme Court's decision cannot be charged under those 2 criminal code provisions. So there's no new mechanism or
there were 3
rules.
conditions, you're saying?
The Supreme Court laid out 3 conditions that have to be met in order for physicians to be essentially excluded from being charged
So this
under
is
the
like
code.
the irremediable suffering.
So the person who has, I guess, received assistance in dying or in their suicide
Yes.
has to show clear consent by a competent adult. The adult has to be suffering from a grievous and irremediable medical condition
Yes.
that causes intolerable and enduring suffering to that person in their own circumstances.
So it's kind of very general and very vague.
Absolutely.
Okay, so then the government or whoever has to take those 3 conditions and write something that works.
Well, those are the Supreme Court's conditions.
Okay.
It really is opening up, they're saying that their decision or the protection, I guess, that they offer to doctors who provide assistance to patients who meet those conditions will be protected and cannot be charged under those criminal code provisions. But it's really up to, for example, the federal government would be free to write a new provision into the criminal code that lays out their own proposed mechanism or rules or conditions that physicians have to meet or that patients have to meet in order to access this.
See. So when we look at the recommendations or the proposal or the proposed changes, that's what you're talking about. So because that's more than just 3 things, it's like 9 pages.
Absolutely. So I think you might be referring to recommendations that came from the Joint Parliamentary Committee that was struck on this. Their work was quickly done, I think, and released at the end of February, wherein they made 21 recommendations to the House of Commons. So this was a committee struck by the federal government. There were members of Parliament and members of the Senate who were part of this committee, and they heard some testimony from a wide variety of groups. And then issued a report recommending 21 items to the House of Commons while they go through this process of trying to determine how they are going to respond and what law they're going to put in place. So those recommendations from the Joint Committee are not law yet. They're essentially what the committee thinks the federal parliament should consider when they're going through this process.
And in fact, by the time this interview airs, we might already know what the proposed law will be.
I mean, any day now we should we should expect to hear something.
Okay, let me also back up a little bit because, I mean, in 1993, I think a lot of our viewers might remember the Sue Rodriguez case, and maybe some people might have thought that was kind of, we took care of that. That was 20 years, no, 20 years, 5 years
23,
ago. So 23 years ago.
Yeah.
So how did we get from there to here?
Yeah, I think that's a really common question because that case was very public and there was just a nationwide debate at that time about whether this was going to change. And so Sue Rodriguez brought this essentially the same case ultimately to the Supreme Court. It was the same 2 criminal code provisions that she was arguing violated the charter. And at that time, the Supreme Court of Canada, in a very tight decision, 5-4 judges, found that no, those criminal code sections did not violate the charter. And so, I think certainly people are surprised that
but is it as simple as we have new judges today?
Well, certainly that's one of the big changes is that there's a new panel, but the court had to address that. The British Columbia Supreme Court, where this most recent case started, had to address that. And at the British Columbia Supreme Court, a large volume of evidence was introduced to the judge at that instance, which addressed the previous concerns that there was no way to sort of control or put in safeguards to continue to protect vulnerable people.
Yeah.
And there was certainly no evidence available to the court in 1993 on that issue because it hadn't been legal anywhere in the world
so in
until that
1993,
time.
no Belgium, Holland, none of those countries?
No, I think
Oregon?
1993 was the
Really?
year that perhaps the first European jurisdiction did put in some kind of rules into place. So there was no evidence before the court at that time.
Interesting.
And there was, a large volume this time around that ultimately the trial judge at the British Columbia Supreme Court did accept that evidence that there was a way or there were mechanisms that you can put in place to prevent misuse of these provisions.
So let me ask you, so those are what people call safeguards.
Yes.
And people talk about safeguards, they look at other countries or other jurisdictions, mainly the Netherlands and Belgium, I think, where some people will say, well, the safeguards do work. We can create a law that's going to make sure that it's not going to be misused. In your legal opinion, are safeguards useful? Or maybe not useful. Do they work?
I haven't studied how those other jurisdictions operate.
Okay.
I'm certainly not an expert on kind of the medical processes that people have to travel through when they're trying to obtain a service like this. I think that one of the, certainly, and having said that, I'm not an expert in this. I think that the mechanisms that are in place in the European jurisdictions are broader than they are, for example, in Oregon, Washington, Montana, where the laws are newer there again. And I think that a lot of the evidence that the court ended up accepting were from those American jurisdictions where the laws haven't been in place for as long, but they've found, and the court accepted that there is not a sufficient abuse of.
Well, does the fact that we have this Charter of Rights here in Canada make it more difficult for the safeguards to work?
I'm not sure that there's an interplay between the safeguards and the charter. The safeguards are more kind of procedural. They're like, for example, a waiting period where if a person is asking for physician-assisted death, they kind of have to wait a certain amount of time before it's actually provided.
They have to
a number of doctors have to sort of sign off and meet with the person and make sure that they're competent. So it's those kinds of safeguards that we're talking about.
Okay, as opposed to what I was thinking, and maybe this is not a safeguard, it's a limitation perhaps, the age of consent, that right now the recommendation is that it's 18, but I know that's already been challenged and we don't have a law yet.
Well, the Supreme Court specifically stated that their decision only applies to people over 18, so competent adults over 18. Yes. I think one of the surprising recommendations from the Joint Committee in their recommendations was that it ultimately be made available to what are called mature minors.
Yes.
And that certainly was not something contemplated by the Supreme Court of Canada. The recommendation is in fact to ensure that physician-assisted death is made available to mature minors within 3 years of the initial law being passed.
Right.
So I read an article in the newspaper just last weekend indicating that recommendation in particular has been a surprise to Canadians, and it may demonstrate the line that even people who accept physician-assisted death might be on, we're not ready for that.
Well, that once you open the door, you've opened the door. Another limitation or safeguard, I don't even know if there's a distinction, involves conscience rights, that a medical practitioner, doctor or nurse should be able to refuse and not have to refer.
Yeah.
Where do we stand with that?
Well, the Supreme Court again was clear in their decision in stating that nothing in their decision would require a doctor to assist someone else in committing physician-assisted death or assisted suicide. So, there's some uncertainty about what that means. Does it mean, even under the Supreme Court's decision, does it mean that doctors have to provide a referral or assist someone to find a doctor who will help them.
Yeah.
So that's not settled. But at least they recognize that that will be an issue. The response to that so far from, for example, the Alberta College of Physicians and Surgeons has been to preserve physicians' conscience rights, to say that no, they won't be compelled to provide the service. And I'm not sure that it's been settled as to whether they'll be required or encouraged to still provide a referral, because of course many doctors feel that providing a referral even is being complicit in the action itself.
And you mentioned that here in Alberta, a decision has been made. That would be different in every province.
Certainly that would be up to each college. I think almost every province has literally what's called the College of Physicians and Surgeons. So certainly that'll be up to each province. And I'm not sure if there's still ongoing discussion or if even that policy has been completely finalized here, but certainly at this time that's the message from the college here in Alberta.
Is there, again, another safeguard or limitation that can be written so that we can prevent this from happening to people without their consent?
Well, I presume that will be a strong element of the regulation, either from the provincial government or the federal government. That's really the linchpin in a lot of legal tests. For example, to write a will, you have to be competent. To write a personal directive or what's commonly known as a living will, you have to be competent. You have to understand what you're doing and have your wits about you, kind of colloquially. So certainly I presume that will be a strong component of any of the regulations that will end up governing physician-assisted death.
I'm just curious now, because that's what the kind of law that you do. Have you been in situations where there have been dispute over the competence of a person when they wrote their will?
Oh, absolutely. Yeah. My practice includes estate planning, so I help people to prepare their wills, prepare their personal directives, prepare their enduring powers of attorney. But I also am involved in court cases when there are complaints or concerns brought to the courts through lawsuits about whether the will is valid or the personal directive is valid. And I think that's one of the ways that the court found, that's one of the safeguards, for example, that the court is sort of relying on doctors and lawyers to protect and ensure that when these decisions are made, they are only made by competent individuals. And so doctors already are heavily involved in assessing competence. Even when a decision has to be made to withdraw care, which certainly is already available to doctors, withdrawing or withholding care or further treatment. That's not the kind of decision that went before the Supreme Court of Canada. That's the kind of work that doctors are already doing. And so even when doctors are taking those kinds of instructions already from patients, they have to assess their patients' competence or ability to make those decisions.
Yeah, how hard is that?
Those are very difficult matters where there's concern. Absolutely.
I'm curious also about the issue. I mean, we're talking about amending the criminal code, but we're also talking about something that seems to be a health jurisdiction. How do even those two things come together?
Well, that's there are always fights between the province and the provinces and the federal government on jurisdictional issues. There's a wide body of law, constitutional law, wherein provinces want to regulate in a certain area, and it sort of overlaps.
Is that what happened in Quebec? Because in Quebec, this is already legal, but it's not.
Yeah, Quebec had kind of right off the bat put in place some procedures, and they've been operating.
And it's under their Health Act.
And I think that probably just because it's been in place and it's maybe in that kind of period of uncertainty and almost a legal vacuum that no issues have been made of that. And Quebec's legal system is different as well. So, and I'm certainly not an expert on that
Do you think
system.
that how much will the federal, I guess, I don't even know who's writing this law, will look at what's happening in Quebec and use that as a model? Is that?
Certainly, I'm sure that all of the provinces are looking, not necessarily to copy the Quebec model, but certainly they're the first out of the gate at least. And I'm sure that the provinces have at least looked at what Quebec has set up.
Right. Okay, and again, to clarify, so federally, the criminal code is changed, but how that applies or how those, and I hate to call them services, are delivered is a provincial jurisdiction. So that's why we have this.
Right, and there will always be, and there often is, and even in other areas of law like environment or what have you, there's often an overlap between what the federal government can pass laws about and what provinces kind of are in charge of. So that just has to be played out essentially. In this case, the federal government's only kind of role in it likely will be on the criminal code side, but the provinces, as you said, are going to be administering the health services. And then the other important body that we have to look at too is the medical regulatory bodies, so College of Physicians and Surgeons, the nurses, the pharmacists. They're all going to be involved in whatever requirements or mechanisms or rules for their own profession that they put in place will affect how Albertans, for example, again, access this service.
How much is language a part of this? So that because they're calling it medically or physician-assisted death.
The Supreme Court calls it physician-assisted death or dying.
Would that include both euthanasia and assisted suicide?
That includes voluntary euthanasia and physician-assisted suicide.
Euthanasia being the doctor actually kills the patient.
That's right. So, and it's an important distinction to continue to specify that this is voluntary euthanasia, because euthanasia as its own term is the killing of another person with or without their consent. So people may also remember the story of Robert Latimer from the 1990s in Saskatchewan, who euthanized his daughter Tracy. She was 12 years old, I believe.
Severely disabled.
Severely disabled, and euthanasia also include in the definition of euthanasia includes an intention of mercy.
But none of this is even using any of that language, because the word euthanasia is nowhere anywhere to be found, and the word suicide is nowhere ever to be found. It's medically assisted dying.
So physician, and the terms were defined in this case that ended up before the Supreme Court of Canada. The Supreme Court itself didn't define the terms that it was using, but it used the same terms and presumably definitions that were developed and used in the British Columbia Supreme Court. And so it's that case from which we say that physician-assisted dying includes both physician-assisted euthanasia, wherein the physician actually applies or provides the drug cocktail in this case, as well as a doctor providing a prescription which the person can take themselves. Yeah.
Wow, there's a lot here, but I think this has been very helpful. So what happens now? You said that we're waiting.
We're waiting until June 6th, at which point the criminal code will not apply to any doctors who assist people with their to die.
Yes. And hopefully by then we'll have.
And hopefully by then we'll have more rules in place, again, from the doctors, from the pharmacists, from the provincial governments, and from the federal government. But in the meantime, people have already accessed physician-assisted death because the Supreme Court of Canada allowed, or sort of said that they can, in the meantime, between February 6th and June 6th, they can make an application to the court in whichever province they reside to ask a court for an order to allow them to have a physician assist them in dying. And in fact, that's being used in Alberta already.
Okay, and then in closing, I think I want to remind people, and of course this is what you do, but if people are concerned about directives, they should make sure that they have a living will.
Absolutely. In Alberta, we refer to them as a personal directive. It's unclear as to whether you'll be able to include, for example, if you want to access a physician-assisted death, we're not sure if you'll be able to do that in advance through a personal directive. But if you don't want that to happen to you, Make sure that your personal directive is clear on that. And the other thing too is make sure you're having that conversation in your family.
Yes.
That's almost the most important element of this. Even when people do have their written documents, we certainly recommend and need people to do that. But you also need to talk to your family and to the people that you're naming as who will be ultimately making those decisions if you yourself lose the competence to do that. You need to make sure that you're giving those alternate decision makers the information that they will need to confidently make those decisions for you. You need to protect them in that way. So it's critical.
Yes, that's good advice. Kate, thank you very much for your time and for your expertise and for all this information that I'm sure we'll still be processing in the months to come. I've been speaking with Kate Faught. She's a lawyer with McLennan Ross here in Edmonton. We've been speaking about the legal aspects of end-of-life issues as they pertain to Canada. Right now, we're taping this program in April 2016. If you have any questions about any of this or about anything you hear in this program, you can send them to us at focus@saltandlighttv.org. You can also send us questions via Facebook or comments and via Twitter. Thank you very much for being with us. I'm Deacon Pedro, and we'll see you next time on Catholic Focus.